folks. This is Kirkland in the Bill of Rights office here. Getting ready to do a quick read. A reading from the man behind the curtain. Let's see what we got here. Okay, apparently I got 1, 2, 3, 4, 5, 6 papers that I wrote, but I'm going to read this top cover paper first to give you an idea of what I'm doing. This is for an objection for David White, and it says, to the institutions in support, the plaintiff requests a investigation on his matter of invoking constitutional rights and forced to enter an unknown contract against his will and put in jail without any way to defend himself against the parties listed as the defendants. We would like your institutions, who are to protect the people, we the people, and now request for your help in the redress of grievance, and to expose the lower inferior courts who break down our laws and commit crimes in order to create a crime for equity. Violating due process and collusion between the bar and judges and police officers who violated the oath of office in Article 6, Paragraph 2. By enforcing conflicting codes, statutes, and regulations that are repugnant to the actual law, the judges and lawyers of the titles of illegal nobility think that the constitutional merits have no grounds and ignore it by trickery schemes and unknown contracts that waive individual rights. They do it every day to everybody, and nobody really realizes it. They have been doing it so long, they think that it's okay to commit treason when the individual knows the actual law, then only treated like a war criminal. We as oath keepers must take peaceful actions to restore the true intent of the law so that America, our great nation, can get back on track and lead the way for other nations and for ourselves. We plead for you to assist and inform all supporting elements for the request to investigate for treason committed under the color of law, titles 18 U.S. 241, 242, 1628, 2183, and also under the color of law, titles 42, 1980 cases. That seem to be all under a hidden contract to rob the public. When a man or woman invokes his God-given rights at any time, he shall not be treated like a war criminal. If one does this, it could be very dangerous to the masses and those true Americans and institutions. This puts officers and public in danger. We should always protect life, limb, and property and preserve our constitutional rights of all sister states in harmony, and hold all accountable for destroying our nation within. As an ex-soldier, I am also reaching out for your assistance to investigate so that if there is evil intent or by error, that it can be dealt with in a timely manner and restore our true intent of the law. If one does not know, then it's what they say it is, and they can't say anything. It's time for us to unite and lead the way, especially those who have been given the lawful authority to protect and serve. Love, Kirkland. Even though I help those in need behind the scenes, I am also in danger for the discovery in my studies of the true intent of the law. I would hope all institutions would assist and protect me as well. We all must join together. Okay. Let's see what we got here. Okay, now this is to a paper I wrote for Mr. David Kendall White. He's in jail. They're holding him under against his will. He didn't sign any paperwork. He didn't contract with them, but they're treating him like a war criminal as we speak, and we're working on getting all institutions involved, and we've contacted the FBI, every institution you can imagine we've contacted, and even resources in my personal connections as a 11 Bravo soldier, ex-soldier, a soldier forever anyways. Okay, it says Montana 10th Judicial District Court, Fergus County. Dwayne Kirkland with all my information. He's got all the titles of nobility that I claim hold under the private side. I might as well tell you what they are. It's the Dwayne Kirkland UCC 1-207.4, 1-308 without prejudice, supporting parties, Overwatch 11 Bravo Infantry. For the record, civil, criminal violations, gives my address, Officer Kirkland, my emails, phone number, titles of nobility, Bill of Rights office, self-claimed constitutional officer, investigator, collections of evidence, secure evidence, and advocate. Wow, I got a lot of titles. Anyways, plaintiff, claim beneficiary David Kimball White, UCC 1-07, 1-308 without prejudice. Case number DC 14-2018-13. It's in Fergus County. A judge filed a motion to obstruct and stop all paperwork filed by any advocates in support of David, because David can't file any paperwork because he's in jail. He's been put in the role and treated pretty much like a war criminal, so everybody on the outside is filing papers for questioning and bringing their criminal acts on the record, but they keep striking it down. And this judge, Oldenburg, I believe his name, Oldenburg, Judge John Oldenburg, filed an order to strike any paperwork down because he used some kind of claim to rule. Get this now, he didn't write the motion order for an actual law. He wrote a rule. A rule is not law, okay? Just because a judge says this and it's a rule, it's not a law. Laws trump other laws. There's supreme law, there's state law, there's miles and miles and books of law, and most of them are not actual law. There's only I want to say a certain amount of percentage of actual law, which is a constitutional law that the Americans go by, but they've been tricked and been utilizing the code, statutes, and regulations and rules so they can justify it. And if you don't know it, we just kind of have respect for authority figures and we just go with the flow. And what you understand is that you're just waiving the actual rights to the law that actually stands. But anyways, there's many different reads of elaborated on before in other videos. But anyways, so the judge filed paperwork and he ordered it to 6 different people. Okay, Diane Cochran, Deputy County Attorney, Prosecuting Attorney, Office of the Public Defender's Office, Billings OPD Conflict Office, and then, of course, Mr. Cordell, one of the advocates that was actually filing the paperwork. And the judge wrote down the rule that he claimed is 11 Alpha MRCIVP, and that's the rule that he claimed to justify his practicing law from the bench when it's supposed to be the trial factor. He's right there, he's in violation of code of ethics. He's not even supposed to be acting like the prosecuting attorney, but he's acting like the prosecuting attorney. He's supposed to let the prosecuting attorney do his job, and the defendant or whoever everybody has a distinctive, descriptive role in due process. And clearly this judge has violated the canon of ethics and violated ethics drastically. Okay, so I wrote this paper. This is just a cover sheet. I don't know if you guys can see it. It's probably not very good. Actually, you probably can't see it, so the videos, I wrote an objection to rule, and I wrote repugnant to due process, and it says the plaintiff David K. Kimball White, filed by supporting advocates and supporting institutions, order to clerk of court to perform specific duties. Comes now the above entitled court in orders as follows. Discussion and conclusion of law. Now here's the actual law compared to rule, okay? This just slams the judge's order. So it's number 1, the clerk of the court is a ministerial position, not having authority of a tribunal. As such, it is required to carry out its duties without acting as a tribunal, but by merely performing the duties authorized by the court. One of those is the duty owed to the plaintiff to file documents presented for the record. Failing to file documents for the record is a criminal offense. You get that? Number 2, a document is considered filed once it is received. Number 3, the clerk of court, like a recorder, is required to accept documents filed. 4. The Federal Rules of Civil Procedures was the agreed format for the court proceedings. 5. A paper is filed upon delivering it to the clerk, 5D2-2. 6. The job of the clerk of the court is to file pleadings and other documents, maintain the court's files, and inform litigants of the entry of court orders. Sanders versus Department of Corrections, 815 Foxtrot, SUPP, 1148 Hotel 49, ND 1993. That's one case clarifying the job for the clerk. Williams versus Pukinski, 01C5882, ND 0113 2004. Another case. The duty of the clerk is to make his record correctly, represent the proceedings in the case. Whitmore versus Carrick, 27 SCT, page 434, 205 U.S. 141 U.S. 311 1907. Failing to file documents presented and reflected the documents on the docket is a failure to perform the ministerial duties of the clerk of court. It is hereby the order of this court of the record that the clerk of the court for the future business to correct the errors or mistakes. State of Montana, Fergus County Justice Court. Clerk and judge and listed defendants. To the guards of the constitutions in harmony, fulfill its obligations under the authority of law and file any documents presented for said purpose for future filing or answers to complaints, warning with respect to correct errors for violating the process. Diminishing rights is a crime. If stricken off record, then a dismissal should be granted. Witness seal, and then on the very bottom, it gives another court case, number 11. It is settled law that delivery of the pleading to a proper official is sufficient to constitute filing thereof. United States versus Lombardo, 241 U.S. 7336, 508 LED 897, 1916. Milton versus United States, 105 F2D 253, 255, 5th Circuit, 1939. In Grayson versus Sherman, okay, I just got multiple cases just elaborating on it in closing what I read to you and the facts. Now here's the last case. It was held that a pleading delivered to a deputy clerk at his home at night was thereby filed. So you can go directly to their house and give them paperwork and interrupt them at 2 or 3 in the morning, and you give it to them, and then it's considered filed. So that kind of tells you how important it is that they can't mutilate, destroy, or deny any paperwork filed on your behalf. And it doesn't matter who's filing it. It doesn't have to be an attorney. That's what they want you to believe, because if you have an attorney won't file that stuff for you, because he's under contract with the judge, the prosecuting attorney, and the bar. They are all under a contract, and they're not going to break the contract to, if you offer your attorney that was appointed to a one-page contract stating that you will protect my constitutional rights and my common law, or whatever you want to put in your contract, I guarantee you that attorney will not sign it, and he will file a motion as soon as possible to recuse himself, and then you'll be without attorney, which is fine, because you don't really want an attorney anyways, because they're all on the same side. You need to go in there, file your own paperwork, and say, hey, there's no victim here, no property damage. I really ain't got too much to elaborate or say on that, but here's what I want to do, Your Honor. I would like to first question jurisdiction to the prosecuting attorney on the record, in writing and verbally, for that prosecuting attorney to prove that he has legal or lawful authority over me in this situation. And I'd like a legal determination for the record, period. That's the first thing, and you stick to that until either the judge answers you, or he'll probably make some excuse to answer you, no, well, they do have jurisdiction or whatever, and he'll throw something. And you say it again, you object, and you say you'd like a lawful declared determination in writing, an answer. Okay, that's the first thing. The second thing is when you're in there, the first, any court procedures, a lot of times they get you in the minute hearing or the omnibus hearing, or any hearings directly after that. What they usually do is they try to get you to waive your rights at the minute hearing, and a lot of people do, and they don't even realize it. It's trickery scheme that the the three individuals do against the so-called person that committed a crime, which is, they didn't commit a crime because he's not really a victim of property damage or any violations against the constitutions. So what they do is, these codes, regulations, they tell you it's law, but it's not law. They don't have elements of the making of being law. There's no enabling clauses, and there's not other special elements that require it to be law, how it was made. Even if it was made and it did have the elements, you can always question that code, regulation, or law, whatever they claim. You can always declare that it's repugnant if it's in conflict with any part of your Constitution or any part of any sister state constitutions that are in harmony. So people, that's why it's important for you to read all the constitutions. You're going to find when you read them, they all pretty much say the same, but they're just a little word game going on, a little bit of numbering trickery to trick the libtards and the ones that have been programmed in the liberal libtard colleges. All this language in the law is actually written at a 6th grade level, and actually lower level than that. All you got to do is read some of the actual Federalist papers to actually get the true intent of the law, and you'll find out we've been tricked for so long. But anyways, we're into, let's see, I don't know how many minutes we're in here. 16 minutes, so we're pretty long. So that's the objection I wrote for Mr. David Kendall White on his behalf, even though he's incarcerated in the hole as a war criminal right now. Then what I did is I wrote a paper, declared Q Warranto warning, which I'll have another video on that and read that to you specifically. And that's a warning. You really don't want to exercise that Q Warranto unless you got a bulletproof vest and you got backup, because they will kill you. Because you're talking big money there, and you can just shut a whole city or franchise down immediately, and you can own it. And people don't realize that they have that power to do that. But, that's another reading. I'll probably do the next video on that. And then I wrote another paper for, the Q Warranto was like 11 pages. Then I wrote Mr. I declared for David Kendall White on a treason complaint. This is beautiful. I love this one. This one's, I'll do a reading on that one too. Claim criminal acts, and that was a pretty long. That's 7 pages. Then I wrote a bill of attainder, a bill of pain, and that one is 2 pages. Everybody should know that. Then I wrote the grounds for the bill of attainder, and that one is 1, 2, 3, 4, 5 pages of my own format, and I'm learning the actual format of it as like an attorney would be. Like I said, I don't claim to be an attorney, I don't want to be an attorney. I am the one that the attorney's mothers warned them about. That's me. Okay, and then the very last one, I wrote another paper for David, a criminal complaint, declared void and null. I declared the minute hearing that he had void and null, the omnibus hearing, the bill of attainder, the bill of pains. I declared them all repugnant and void and null, and the warrant that they issued that actually they got him in jail for it. So that is that's 8-page. So I'll read that one in another video. And then I made one special contact, and actually I discovered 2 other contacts besides the marshal's offices. I got information on that I can share with the public eventually. And I got some contacts for D.C. over on Pennsylvania. It says the U.S. Department of Justice Civil Rights Division, Special Litigation Section, PHB, 950 Pennsylvania Avenue, Washington, D.C. This is who I'm going to contact with all these documents for Mr. Kendall. I mean David Kendall White, Mr. White. Anyways, that's what I do, and I'm going to have to say thank you for listening. God bless you, and I love you all. And I will do the next reading on the next paper. Thanks.